I'm Eric Claeys, and I'm pleased to welcome you to Panel 3, Preclusion and Deference. In our first panel, our panelists offered different perspectives on how administrative law and private law relate to each other and to intellectual property. In our second panel, panelists explored whether there may be or should be less administrative law in IP than there is now after the American Invents Act injected a heavy dose of administrative law into patent law. In this next panel, we'll assume that administrative law is here to stay in patent law and other fields of federal intellectual property. And if it is here to stay, lawyers and scholars have more to do to clarify how it operates in intellectual property. In particular, the American Invents Act transplanted into federal patent law some institutions familiar to specialists in administrative law. But some of those transplants may not take so well. Patent law has quirks, peculiarities that don't arise in other regulatory contexts, and administrative lawyers and patent lawyers have better mind those as they apply general administrative doctrines and principles to IP. Panel 3 studies two contemporary legal problems raising these sorts of questions: preclusion and deference. Assume that administrative adjudicators render conclusions of law or fact about patents in regulatory disputes. Do those judgments settle the relevant disputes for all purposes, including in courts? That raises a question about preclusion. Or assume that administrative officers interpret federal statutes about IP in the course of setting policies about IP. Should courts let those officers take the lead? Those are questions of deference, and we've heard lots about those with Chevron and Skidmore earlier today. Now, what I just said provides only the barest sketch of the two main topics of this panel. More needs to be said just to define the relevant issues, let alone talk intelligently about what's good and bad and how to make good progress on any of them. And those are the tasks of our panel today. And let me introduce our panelists, and I'll do so in the order in which they're going to present. We'll hear first from Melissa Wasserman. Professor Wasserman is the Charles Tilford McCormick Professor of Law at the University of Texas. Her research focuses on the institutional design of innovation policy, with a particular emphasis on patent law and administrative law. She recently published the article, The Changing Guard of Patent Law, Chevron Deference for the PTO, in the William & Mary Law Review 2016. We'll hear next from Megan LaBelle. Professor LaBelle is Professor of Law and Co-Director of the Law and Technology Institute at the Columbus School of Law, Catholic University of America. Professor LaBelle teaches and researches in the areas of intellectual property and procedure. She recently published Public Enforcement of Patent Law in the Boston University Law Review 2016. Batting third, we'll hear from John Golden, not to be confused with John Goldberg, the torts professor. Professor Golden is the Loomer Family Professor in Law, also at the University of Texas, and Faculty Director of UT's Andrew Ben White Center in Law, Science, and Social Policy. Professor Golden's research focuses primarily on issues relating to innovation policy, institutional design, patents, and remedies. He's the author of Working Without Chevron, The PTO is Prime Mover, Duke Law Journal 2016. And cleanup, we'll hear from Kristin Hickman. Professor Hickman is the Distinguished McKnight University Professor and Harlan Albert Rogers Professor in Law at the University of Minnesota. Professor Hickman is a leading authority in the fields of tax administration and administrative law. She's the author, along with Matthew Kruger, of In Search of the Modern Skidmore Standard, Columbia Law Review in 2017. Professor Wasserman, the mic is yours.
Okay, so thank you very much to the organizers. It's been a really stimulating and interesting conference so far. So what I want to talk about is a little bit the deference standards, and in particular, whether the applicability of Chevron deference to PTAB and also TTAB. Okay, so the Patent and Trademark Office, right, has two primary decisions it makes. It's whether a mark meets the federal registration requirements and whether a patent application meets the patentability requirements. And so if the Trademark Office approves the mark for registration initially, right, a third party who believes they're going to be damaged by the registration of the mark may challenge the determination in the Trademark Trial and Appeal Board, named as the TTAB. And it's an administrative tribunal in the agency in which you have three-member panels consisting of administrative trademark judges, which are non-ALJs, preside. And these inter-party proceedings before TTAB are very formal-like. They're largely governed by the federal rules of civil procedure. They allow for discovery and depositions. They allow parties to submit testimony under oath and to cross-examine. And you can request an oral argument. Now, those TTAB decisions have been around for a while on that inter-party proceeding. They're not relatively new. But you can't appeal that to the agency head. So the TTAB makes a decision. You can ask for a rehearing, but that will occur by the board. You can appeal that decision directly to the Fed Circuit on that record, or you can also appeal it to a district court, which divests jurisdiction from the federal circuit, where you can add new evidence, and then it gets appealed to the regional circuits. So on the patent side of things, you have something similar now, right, as we've been talking about. We have PTAB, which has these new robust streamlined ways for third parties to challenge patents that have been granted at the agency. And similar to TTAB, you have 3-member panels of administrative patent judges, non-ALJs, that preside. And you also have very formal-like proceedings. You have an oral hearing, you have discovery, right? The agency has promulgated a bunch of regulations for ban on ex parte communications, etc. But similar to TTAB, you have no agency head review. You have the same sort of rehearing structure, and it has a somewhat similar appeal where you can appeal directly to the Fed Circuit on the record or to a district court where you get a trial de novo, arguably, but that appeal does go to the federal circuit. So what does this mean for the deference standard? So I'm going to focus on TTAB or PTAB's legal determinations that are getting appealed directly to the Fed Circuit, right? And whether we can argue or make a good argument that Chevron deference should apply there, right? And so as everyone probably knows here, right, under Chevron review, an agency with force of law authority who has exercised that authority will have its reasonable legal interpretations of ambiguous terms, right, upheld. The question, of course, is how do we know when an agency has force of law authority? Supreme Court and Meade provide us with some guidance here where they said generally a congressional grant of formal adjudicatory or rule-making power is, quote-unquote, a very good indicator that Congress intended for that agency to speak with the force of law. Right? The Supreme Court's deference jurisprudence for Chevron has extended Chevron deference to things that are very formal-like, even if they don't technically fall under APA-governed formal adjudication. And this is, we know in admin laws, Type B adjudication. So the question then I think we'll start with is TTAB or PTAB APA-governed formal adjudication? I think the best answer probably is no, and I'm going to focus a little bit more on PTAB right now, because typically if Congress intends to grant an agency APA-governed formal adjudication, they use these magic words, hearing and on the record, and here in the Patent Act, when they talk about PTAB proceedings, they just use the word hearing. And circuit courts have come to divergent approaches on whether hearing enough is to trigger the APA-governed formal procedures, but the dominant approach is to apply Chevron deference to the agency's interpretation of whether these formal procedures apply. Here, you've never seen the Patent and Trademark Office take an explicit position to say that PTAB is APA-governed formal adjudication, but you could argue implicitly they don't think so because there's several procedures or aspects that are missing. And one, I think that's most salient, is that the Patent Act requires you to use administrative patent judges, not ALJs, which are typically found in APA-governed formal adjudication. And there's also no direct agency head review, which is also something that you would find. So if it's not that, what are they? I think it's best described as what we call Type B adjudications, which are you have a statute that requires an evidentiary hearing, and they're often presided over by non-ALJs, but something called administrative judges. AJs typically have less protections than ALJs, but they can be very formal-like. Right? And these Type B adjudications are found everywhere in administrative state, and sometimes they're even more formal than APA-governed formal adjudication. And so what does this mean for deference that could be afforded to PTAB, right? As I noted above, right, we have the Supreme Court has granted Chevron deference to a Type B adjudication, which is the immigration appeals, right? And this may be, the Board of Immigration Appeals may be the sort of predominant Type B adjudicator in the modern administrative state. And so then I think you left to this question about whether there's differences in the structure of sort of the immigration appeals versus PTAB or TTAB that would suggest maybe you get Chevron in immigration but not in the PTAB or TTAB context. And so I think there are a couple of factors that you can think about that, because it's going to come down to whether you give them a grant of formal-like adjudication, what is associated with that suggests Congress meant for them to speak with the force of law. So you can think of things like when the agency uses these adjudications to bind everybody in the agency as well as the parties, right? You can think of things about you want the agency head to be involved in this decision because it doesn't make perhaps a lot of sense that Congress would grant force of law authority to a lot of low-level decision makers, right, that are making high-volume determinations. So one question that you could ask, right, is does the lack of agency head review matter in this context, right, with PTAB and TTAB? Because if you look at immigration appeals, what you have is you have the Attorney General has referral authority, which in essence is sort of a discretionary way for the Attorney General to review any of the immigration appeals, right? And so I don't find that enough persuasive to say Chevron shouldn't apply, because while you don't have direct agency head review, what we have talked about is the director can influence adjudicatory outcomes by stacking the panel, right, in essence. And this idea that the Patent Act essentially gives the director the authority to select APJs to be on a panel, right, and hopes that these APJs will essentially vote or come out the way that she would like. Now, I argue in a piece with Chris Walker that's forthcoming right now that raises a colorable due process violation, but it does suggest that the director has some sort of control. I think perhaps the best cases in which you could say Chevron deference would apply would be applying to the precedential PTAB decisions and TTAB decisions. Because in order for those decisions to be designated as precedential, the director has to sign off and agree that they should get precedential status. And right now, currently, how it is, the majority of administrative patent judges or administrative trademark judges also has to agree. So let me just say a final word about TTAB. So there are some differences that you could say push more towards Chevron or less or against Chevron for TTAB in comparison to PTAB. So one point I want to make is that if this sort of deference should turn on the congressional intent of Congress associated with these sort of formal procedures that are given, you might have a better argument for PTAB, because if you look at the Patent Act, you have a lot more in that statute that suggests Congress really wanted these to be formal-like, right? They grant the director sort of rulemaking authority for a number of different trial-like aspects associated with PTAB proceedings. And TTAB, if you look at their inter-party proceeding, the Lanham Act, right, is very sparse. And it's almost as if the Trademark Office has taken it upon itself to say the best way we think these should be is through a formal-like proceeding, but you could argue there's not as much in the Lanham Act that suggests Congress intended them to do so. Alternatively, though, I do think you could argue that the fact that TTAB has a smaller number of adjudicators, right, that may sort of push more towards Chevron in that dimension.
I actually have slides. Hey, thank you very much for inviting me here today. This has been a great panel so far, so I'm really happy to be participating in it. So as Eric mentioned earlier, the title of this panel is The Limits of Preclusion and Deference, and so I'm going to be focusing on the preclusion part of that. So questions of preclusion have come up in patent law for a long time now, but with the creation of the PTAB and the enactment of estoppel provisions in the AIA, the issue of estoppel has become increasingly important over the past few years. So before I get into the PTAB estoppel and some of the questions that have come up with respect to PTAB estoppel, I wanted to say a few words about preclusion generally. So I'm not sure, there are some proceduralists in the room. Some people might have some vague concept of preclusion or maybe are very familiar with it, but I wanted to just give some basic background about preclusion. So preclusion is a common law doctrine that arises when there are two proceedings. So these can be two judicial proceedings. It can be one judicial proceeding and an administrative proceeding, as the Supreme Court confirmed recently in the B&B hardware case, a trademark case. And essentially, these doctrines address the question that once a party has his or her day in court, for fairness reasons and for finality reasons, he shouldn't get sort of a second bite at the apple. So there are two types of preclusion. The first is claim preclusion, which historically was referred to as res judicata. And sometimes these, both claim preclusion and issue preclusion, just to confuse us, are generally referred to as res judicata. But I'll use the terms claim preclusion and issue preclusion because I think they're much clearer. So claim preclusion, I have the elements up here so you can see. There has to be a final and valid judgment on the merits. It has to be the same claim, or in some jurisdictions, including federal court, a claim that could have been raised in the previous proceeding, and it has to involve the same parties. And the policy or the objective behind claim preclusion is essentially to encourage parties to bring their claims, to raise their claims at the earliest opportunity for fairness purposes and efficiency reasons. Issue preclusion is similar in some ways, but there are some distinctions. So for issue preclusion, there has to be a final and valid judgment. There has to be the same issue of either fact of law in the two proceedings. The issue actually has to have been litigated, and it has to be necessary to the judgment. And then, I don't know if you can see the final element at the bottom, but the party that's being precluded must have participated in the earlier suit. So I want to sort of talk about that last factor because, as Professor Duffy alluded to earlier, this was not always the case. So before the Blonder Tongue case in the early 1970s, mutuality was required for issue preclusion, just like it still is for claim preclusion. In other words, you had to have the same parties in both proceedings. But in Blonder Tongue, which was a patent case, the Supreme Court changed that, and the Supreme Court created what we now refer to as non-mutual defensive issue preclusion. And there are different requirements for non-mutual offensive issue preclusion, which, in the interest of time, I'm not going to address today. But in Blonder Tongue, essentially the facts for those of you who don't know them, very briefly, University of Illinois was a patent owner, owned a patent on an antenna that was used to transmit radio and television signals, and sued an antenna manufacturer. The manufacturer asserted obviousness and won. And then in a second suit, the patent owner sued another manufacturer of an antenna, Blonder Tongue, and the lower court said no issue preclusion because we have different parties, no mutuality, and the Supreme Court disagreed. And so the Supreme Court said, no, as long as the party, meaning the University of Illinois here, the party against whom preclusion is being asserted was a party in the first action, and all the other requirements of issue preclusion are satisfied, then it's fine that it's non-mutual. Okay, so since Blonder Tongue, it is clear that if a patent is invalidated, then that patent is invalid as to the world, right? So not just with respect to the accused infringer in the suit, but as to other potential infringers as well. So I'll refer to that as patent owner estoppel for our purposes. So what's happened since Blonder Tongue? So I'm going to sort of switch gears and talk about a concept I'll refer to as accused infringer estoppel. So what happens when there's a decision in court that the patent is not invalid. Okay, so does that have preclusive effect? So we know that courts don't determine that a patent is valid. Instead, because there's a presumption of validity that must be overcome by the accused infringer by clear and convincing evidence, if the accused infringer does not overcome that presumption, then the determination by the court is that the patent is not invalid. So does that have some sort of preclusive effect? So, what have courts said about this? Well, certainly if in a second lawsuit the patent owner is suing a different defendant, there's no preclusive effect. Even after blonder tongue, the party against whom preclusion is being asserted has to have been a party. So if there's a new party, no preclusive effect. What about if it's the same party in the second suit? For example, if there are different products, and so the patent owner brings suit number 2. Well, if it's an identical invalidity argument, then the accused infringer will be precluded. But what if the accused infringer raises a different invalidity argument? So let's say instead of obviousness, the accused infringer raises a 102 argument based on different prior art, then does preclusion apply? So we all had some reading assigned to us. We read an article that addressed this topic, and courts are actually split on this issue. I thought this was really interesting. Courts are split on the question of whether invalidity is sort of a single issue. So if you make one invalidity argument on 103 and you lose, does that preclude you from raising a different invalidity, a different ground for invalidity? And some courts say yes, and others say no. Okay, so where does that bring us with respect to the PTAB? Well, this idea of accused infringer estoppel is especially interesting now because that's essentially what Congress codified in the AIA. So before the AIA was enacted, patent owners were concerned that creating these new post-grant proceedings would simply provide accused infringers another chance to invalidate a patent. And so Congress included estoppel provisions. And I've put the language of the estoppel provision with respect to IPRs up here so you can look at the elements. But essentially it bars a petitioner in an IPR from raising in a subsequent action, either in court or at the PTO or at the ITC, from raising an invalidity ground that was raised or could have been raised during the IPR. So this provision has led to some significant litigation, and primarily the question has been, what does it mean if you raised or could have raised a ground for invalidity during an IPR? And lower courts were initially divided on this. Then the Federal Circuit decided in 2016 in the Shaw case that we heard earlier from Ms. Wong about the institution that the PTAB has to decide whether to institute an IPR in the first place. And so in Shaw, the Federal Circuit said that if the estoppel only applies to invalidity grounds that were actually instituted. So if the petitioner raised a ground in its initial petition, but the PTAB didn't institute, then estoppel doesn't apply. So the next question, and this will be my last point, is, well, where do we go from Shaw? So now courts are divided on the question about whether, what if the accused infringer did not raise the invalidity ground at all, even in the initial petition, right? Then does preclusion apply? And courts have actually divided on that. Some have just extended Shaw and said preclusion doesn't apply because that could not have been raised during the IPR. Other courts have sort of relied more on a claim preclusion type of theory to argue that accused infringers should have to essentially raise all their validity grounds at the earliest, or invalidity grounds at the earliest opportunity in considering fairness and efficiency. So I am out of time. I will leave it at that and look forward to talking about these issues more. I guess I'll just leave that up.
Okay, so part of my role is just to react to what has been said so far. I think on the preclusion issue, as Megan has pointed out, I think we have just a number of issues and questions arising that go in part to what sort of how the system is going to work in practice, and how best to strike the balance between trying to force parties to try to raise and resolve as many disputes as possible in a PTAB proceeding if it goes forward, and reserving a proper role for the courts and proper access to court adjudication more generally. And I think this is a situation where for Congress, it was unlikely, it was probably hard for them to predict in advance how this was going to work in practice, and it may be something where Congress always being effective at responding to problems that arise in actual practice, might need to revisit this to give the courts more guidance as to what they intend to be the proper scope of these proceedings and responsibilities of parties to raise issues. With regard to preclusion, one thing that seems somewhat striking to me in how our system works now is how the Congress has taken a quite different approach toward preclusion with regard to proceedings before the International Trade Commission, where you effectively have patent infringement suits brought, the somewhat more limited scope in the sense that the remedies you can get are just going to be excluding material from the United States, or cease and desist orders for material that's in some sense come wrongly into the United States. But there we have proceedings before administrative law judges that do match the model of conventional formal adjudication under the APA. You have review by the agency, potentially presidential review as well of the remedies being granted. And yet the Congress there has been explicit that this doesn't have preclusive effect. And you often have had parallel proceedings going forward in the district courts while these actions are going forward in the ITC. And that makes sense at a certain degree, that we have a greater sense of the binding nature of a patent office decision because of the patent office's traditional role as the primary gatekeeper in that system, and its more specialized expertise in that area. But from one side, because of the highly formal nature, the high quality of the ITC proceedings, it does seem almost a bit anomalous to have the current approach. On deference, well, I've written a fair amount, like Melissa, on some of the technical arguments as to how to understand Mead and what Mead means as to when Chevron applies. I want to put those aside for the moment and just focus on another sort of potential set of concerns in this area just more generally. First, putting aside the sort of technical Mead questions of when a relatively formal procedure provided for by Congress should trigger some sort of presumption or a conclusion that Chevron level interpretive authority has been given. I think for me, one thing that's influential, certainly in my response to this argument in this particular context, is the more specific legislative history that we had leading up to the America Invents Act, where at one point there was a provision put in one of the House bills which was going to give a broad grant of what I would call substantive rulemaking authority to the PTO, more like the grants of authority you have given to other agencies. My recollection is this was not well received by much of the patent community. It was dropped from the bill And also in my recollection in the sort of aftermath of this, but also in connection with another case going to rulemaking by the PTO that was going forward in the courts, the PTO in the aftermath was seeming to disclaim any ambition to have this kind of rulemaking authority and the presumption of Chevron-level interpretive authority that would come with it. So for me, with that legislative history, there are just some concerns about the democratic process in terms of a backdoor way that the PTO arguably gets the same Chevron-level power in interpreting the statute through these adjudicative proceedings rather than the sort of more open delegation of power by an open grant of rulemaking authority. Second, going to the comments that came out in the first panel, I think are interesting questions about the extent to which, just from a general policy standpoint, we want the PTO to have what I'm calling Chevron-level authority on issues such as the meaning of the statutory requirement of non-obviousness. This seems to me debatable given the limited nature of the PTO's review of such issues, partly just because of the volume of work it has to do in initial examination. And in post-issuance review so far, at least with inter partes review, we've seen post-grant review raise some different questions. The PTO's examination, even of issues like novelty and non-obviousness, is limited by the fact that the grounds have to be tied to printed publications or patents, which might be viewed as particularly technical documents that go to the expertise of an administrative agency rather than a court and potentially a jury. So because of that, I've written before that you might imagine a regime where you actually have you slice and dice the Chevron versus Skidmore levels of deference more finely, and that some issues might be more appropriate for Chevron deference. I've argued perhaps subject matter eligibility with proper retroactivity restraints might fit that category, and there are others, arguably potentially like non-obviousness, which often come down to very fine case-specific determinations that might be less appropriate for Chevron authority for the agency. Other potential reasons why this should be viewed as debatable, I think, have been suggested earlier. One, this point that this question of what's the particular significance of having the Federal Circuit in this area, a national, relatively expert court, which takes away one of the benefits commonly of Chevron deference to a centralized administrative agency. And then second, the point raised by Professor Rakoff as to whether the sort of predictability and stability concerns you might imagine are associated with a legal regime designed in some ways to operate like a traditional property regime suggest a potential preference for Skidmore over Chevron. So with that, I'll turn it over to Kristin.
Okay, I want to thank the organizers as well for inviting me to participate in this great conference. It's been really interesting. I am not an IP person. I'm not even very much of a private law person. My role on this panel seems to be that of administrative law generalist, although also combined with my work and my experience in tax law. And you're going, well, what does tax have to do with this? Well, tax is another field that has a tradition of viewing itself as being somewhat different or exceptional from other areas of administrative law, and simultaneously is now finding itself having to grapple with its own relationship with general administrative law principles. So it's always been interesting to me in talking with my patent and IP friends, hearing about sort of these two parallel tracks that are going on with respect to exceptionalism. Anyway, so the Supreme Court has embraced a policy of administrative law uniformity, absent a compelling reason for treating a particular statute or topic differently. The Supreme Court prominently cited this policy in 1999's case of Dickinson versus Zerko, which of course was a patent case, when the court insisted that the Federal Circuit apply Administrative Procedure Act standards of review in evaluating patent cases. The Supreme Court then cited Zerko a little more than a decade later in the case of Mayo Foundation for Medical Education and Research versus United States, when it told taxpayers in the Internal Revenue Service that it was disinclined to carve out an approach to administrative review good for tax law only, absent some good specific reason for doing so. And that Treasury regulations, consequently, that interpret the tax laws would be evaluated under the Chevron standard rather than a different tax-specific standard of review. So in the tax context, we've interpreted the Mayo Foundation case as requiring general administrative law requirements and doctrines to apply to tax administration and to tax cases unless we can point to a particular provision in the Internal Revenue Code as establishing an alternative. What this has meant in the last several years is a substantial increase in the number of cases testing the boundaries of Mayo Foundation, challenging various actions of the IRS on Administrative Procedure Act grounds or general administrative law grounds, and then exploring whether and to what extent particular provisions of the Internal Revenue Code do or do not create exceptions. This jurisprudence is very much of a work in progress, and it's not purely a matter of taxpayers versus the IRS, because the tax bar in general is very divided over whether requiring tax administration to adhere to general administrative law principles is a good idea at all. Nevertheless, it's apparent to me at least that although the pro-exceptionalist side has won a few skirmishes, the anti-exceptionalist position is prevailing overall, with the result that tax administrative practices have already had to change in response to the jurisprudence, and I think will continue to do so. So as I suggested, my sense is that patent law is going through a similar process. And just to be clear, I fall on the anti-exceptionalist side of the argument as a general matter, because I think the Administrative Procedure Act and general administrative law principles advance very important values that transcend subject matter. Every subject matter specialty, to some extent, thinks of itself as being special or unique, and we're all wedded to our own ways of doing things for purposes of accomplishing what we see as the goals of our specific subject matter area. In tax, that's the goal of raising revenue so that government can function. And with all the discussion of patents as private or public, I have to say it does seem to me that the patent system may have a little bit more of a disagreement going even as to exactly what the goals of the patent system are, which may complicate your journey down this path. Regardless, administrative law and the Administrative Procedure Act do have goals that are important as well. Values like due process in the small d, small p sense of the term, transparency and accountability, all in pursuit of facilitating perceptions of legitimacy of administrative action. And as I tell my tax colleagues all the time, if you want to raise revenue, you have to pay attention to taxpayer perceptions of the legitimacy of IRS actions, because if perceptions of legitimacy decline, then collections will too, because there's plenty of research showing that legitimacy and compliance with the law go hand in hand. I don't know exactly how these values play out in the patent context, but at least something worth thinking about as you navigate the relationship between patent and administrative law. Nevertheless, tax and patent in this regard are somewhat different from one another as well, and it's entirely possible that patent administration will remain more exceptionalist than tax administration for at least a couple of reasons that I'll mention. First is you have to appreciate that the relationship between the Administrative Procedure Act and a particular agency's organic statutes is a question of statutory interpretation. So just like no two agencies are precisely alike, no two agencies' organic statutes are precisely alike. Section 559 of the Administrative Procedure Act instructs courts to read subsequently enacted statutes as creating exceptions from the APA only when the other statute is explicit in doing so. That same provision also says that the APA does not limit or repeal provisions of other statutes that predate the APA. So more purposively, courts have interpreted Section 559 of the APA as instructing them to read the APA and organic statute requirements to give maximum effect to both. But where you have a working system of administration that predates the APA, there's some argument for not interpreting the APA to fix a system of administration that wasn't broken. So some of the relevant provisions of the Internal Revenue Code predate the APA. There are some others that don't, so that the meaning and the role of Section 559 has been a part of our discussion in the tax context. And though I know some aspects of the patent system predate the APA, PTAB obviously doesn't. That's a fairly recent thing, and so you can assume, therefore, that Congress was aware of the Administrative Procedure Act, and so it seems that that's, Section 559 of the APA is going to operate in the patent system in a way that, you have to look for some sort of specific indicator that Congress didn't intend the APA to apply. And that's just a little bit different between tax and patent. Again, though, every statute's different. There may be terms in the America Invents Act that can support an argument against Chevron deference for PTAB determinations or whatever. I leave those debates to these folks. They know a lot more than I do. A second reason why the patent experience may be different from the tax experience is that most of the questions in the tax context have come up with respect to IRS rulemaking. Not all of them, mind you, but most of them. By contrast, PTAB is an adjudicatory body. And particularly when it comes to Chevron, I think we're in an unusual moment of uncertainty regarding the Chevron doctrine and agency adjudications. And I know my time's about up. I'm just about to wrap it up. As you may already be aware, we're in the midst of a significant wave of judges, politicians, and commentators criticizing the Chevron doctrine and Chevron deference entirely, with a number of people contending we ought to overturn Chevron altogether. My own view is that it's not likely that Congress or the Supreme Court will overturn Chevron outright, although that's a matter of Supreme Court prognostication that's always a little dicey. But since the Supreme Court's decision in Christensen versus Harris County in 2000 and United States versus Meade Corp in 2001, the courts have been gradually whittling away at the boundaries of Chevron's scope. Justice Gorsuch's particular criticisms of Chevron have been in the area of 1, agency adjudications, and 2, agency interpretations of contracts, i.e. private law. Chevron is at its zenith when agency action comes in the form of notice and comment rulemaking, and the regulation is in the public interest. I think regulation in the tax context fits pretty neatly with that paradigm. But the further you move away from that paradigm, the more other concerns like due process do come into play. And the greater private law orientation of the patent system and PTAB features, like the PTO director's ability to stack a panel, are tailor-made to cause at least some justices maybe to feel a little bit squeamish about applying Chevron in the PTAB context at least. So, you put together kind of those trends, and I think it's at least possible, because it's so much as a matter of statutory interpretation, you can see the justices potentially putting the unique statutory terms of the America Invents Act together with their own predilections with respect to carving back on Chevron's domain, and maybe PTAB actually will remain somewhat exceptionalist. Thanks.
I'd like to thank all of our panelists for their thoughts, and I'd like to thank them in particular for minding my time cues. It leaves a lot of time for discussion, and I'm going to use moderator's privilege here. I thought that the panelists did an excellent job of providing the legal background for covering a lot of the issues, like the different kinds of Chevron, or the different kinds of deference doctrines, the relevant statutes for preclusions. I think some of the panelists assumed some policy values that didn't necessarily come out. I think it might help things along if we get some of the policy issues at least on the table. And I am not an expert in either of these fields, so I'm going to give what I think are rough cuts at the relevant policies to consider. And if I'm wrong, please say so, but I think that'll help any further discussion that we understand what they are. So with preclusion, I think this is primarily for Professor LaBelle, but anybody else chime in. As I would understand it, if you want, the main justifications for preclusion to be wider would be judicial economy and protecting the interest of the litigant who doesn't want to have to litigate the same issue against many different parties. And the issues for a narrow preclusion would be fairness to second or third parties that want a shot at that, and also error correction. And for any of the panelists who have anything to say about deference issues, I think the first question is, does policy matter at all, or is it, as Professor Hickman suggested, is it statutory interpretation, the ascertainment of Congress's intent all the way down? And if it's not just about getting Congress's intent right, what are the policies? And I think they'd be, on one side, deferring to expert determinations by agencies, and on the other side, error correction, and then maybe stopping an agency from making a determination where it's been captured, and a generalist court has a fairer, wider perspective. And any of the panelists are welcome to tackle any of those.
I guess I can start and talk about preclusion. So, yes, I think those are the general policies behind the preclusion doctrine when it was first created as a common law doctrine, and then also with respect to the preclusion, the statutory provision within the AIA. So the idea is we should say judicial economy, right? We don't want courts to have to hear the same claims and relitigate the same issues. Fairness, certainly finality, right? Once you have a final judgment, you should be able to rely on that and not worry about a subsequent lawsuit. And then specifically with respect to claim preclusion, this idea that we want to know what parties' claims are at the earliest opportunity. So turning to the provisions in the AIA, there's been this struggle, the courts have struggled to interpret the provision, and I think that they're doing the best job they can with the language that Congress provided. Part of what I think is going on with some of the confusion is that Congress calls this estoppel, so that sounds like issue preclusion. But in many ways, it looks like claim preclusion. So it has this concept that you can't raise validity grounds, right, that you already brought up in the first suit or in the first IPR, or that you could have raised. That is a concept that doesn't apply to issue preclusion. Issue preclusion only applies to issues that were actually litigated. So this, could have language is not something that, when you're thinking about the common law, that we associate with issue preclusion at all. It's claim preclusion. And so I think part of the struggle here is a terminology struggle, and it's also a policy struggle, right? What was Congress trying to accomplish here? I think they were trying to sort of protect patent owners and let accused infringers know you need to put all your cards on the table early on, because we don't want people sort of holding back their best validity defense in case they lose at an initial IPR, and it was a way to sort of make, I think, patent owners a little bit more comfortable with this proceeding. But I'm not sure that they took the right approach in terms of the terminology.
Yeah, so I could say a couple things. So I definitely think there's a difference, right, in the what would applying the legal standards in administrative law suggests the deference standard should be, and then the normative question, right, as to whether we think the Patent and Trademark Office or the Federal Circuit, right, should be the primary interpreter of the Patent Act and the substantive standards. And I think that the policies that you suggested are the main ones that people consider, right? This expertise, right, as well as capture. And so you may think, and John I think hinted to this, that the existence of the Federal Circuit sort of changes that calculus for the Patent Office relative to other agencies. On the expertise side, we at least have a Federal Circuit who sees patent law and perhaps is more of an expertise than generalist judges. But I don't find that particularly that compelling when you really drill down to what if you're looking at scientific expertise, right, innovation policy expertise, the potential, at least, for the Patent and Trademark Office to do that is much larger, right? The agency has 9,000 examiners, right, who are scientists and experts in that particular area. They have an economic office, although it's still small, that's beginning to tackle on and more of these sort of innovation economic type aspects that I think you would want if you're sort of crafting patent law in a way to optimize innovation. Now, the PTO is not all the way there. It doesn't look necessarily like some other agencies, but I think the thing to keep in mind is the potential, right? It's sort of moving in that direction, and I think it has the ability to do that in a way that the Federal Circuit, I don't think, ever will, right? We have 12 judges, less than half are scientists, right? Many of them with their degrees are even, I think 2 have PhDs, but they're relatively dated now, right? They have 4 clerks. They're just not, they don't have the same ways to gather information, right, that the PTO does. And then capture, I think, is a difficult one, right? The PTO has certainly been suggested that it has a pro-patent bias in the past, and probably most famously, right, when they had this, we're trying to help our customers get patents, right, as part of their policy, right, at one point in time. However, you know, one person can say is and historically they haven't had a ton of power, so maybe people haven't been sort of rent seeking in a way that we might see, right, if they begin to get more through an application of Chevron deference. But that being said, the Federal Circuit certainly has had its own charges of having a biased view on a pro sort of patent view as well.
Okay, just a couple of things. I always hear tax in my head when Melissa starts talking about patents, because she's talking about pro-patent bias, and I can't tell you how many times I hear about the IRS and the tax court having an anti-taxpayer bias, you know, and yet at the same time, you know, how much does that weigh into your evaluation of the application of administrative law principles? Getting back to the question, just as a matter of theory about Chevron, one thing you have to appreciate is that there are many theories and views of Chevron as there are law professors teaching about Chevron. But that said, my own view, at least when it comes to sort of the statutory interpretation versus expertise point, is that expertise is a reason why Congress delegates, but the Supreme Court's made pretty clear that it's a matter of congressional delegation and thus statutory interpretation all the way down. Now, maybe part of what you evaluate in ascertaining whether Congress intended to delegate authority to the agency to act with the force of law is whether you think the agency has the kind of expertise that would have prompted Congress to delegate. But that's a slightly different question than just asking about expertise as its own predicate for Chevron applying. You know, so that's just where I come out on it. But I also think that seems to be more or less consistent with the trend in the case law, recognizing that, you know, I don't want to overread that or overstate that by suggesting that there's anything remotely resembling a monolithic view of how this all works.
I want to leave maybe 10 minutes for questions, but do the panelists have any one thought they want to pass on about what any of the other panelists thought? Or what any of the other panelists said, I meant to say? No? No. More time for questions. Why don't you go up to the microphone? Professor and the distinguished Honorable Keefe.
Well, then, this is an embarrassing question for that lead-in. Why do any of you have a theory other than historical happenstance for why Tom Clark's Attorney General manual about the APA explicitly says this new statute that I've kind of asked for and am proud to get really is not supposed to apply to, and then he goes ahead and names the tax court, the Court of Customs and Patent Appeals, which was the predecessor to the Federal Circuit, and then the claims court. Is it like he said it, who cares, doesn't matter, he just didn't want to annoy the political situation at the time, or did he have kind of a theory in mind?
I don't know that, I have no idea whether he had a theory in mind at the time. I would be surprised if he didn't have a theory in mind, or at least if Ken Davis and others who influenced the APA didn't have a theory in mind. One aspect of it could be, at least, and I can only speak with respect to the tax court, but there genuinely is sort of a perception and understanding that, although it doesn't sit well with the tripartite structure of the Constitution, that the tax court is not an agency. There's a little bit of debate over whether it's a court of law, as the APA specifically exempts. The definition of agency leaves out courts of law. The tax court is not a court of law for Article III purposes, but it very easily could be a court of law for statutory purposes, and the same could be said of the other courts that you mentioned. And so, though I presume that might have been what was motivating it.
Could you, next question's on the audience's left side. Could you introduce yourself too?
Okay, Joachim Martillo from MinRisk Software, which is my own consulting company. And have the post-grant proceedings, and in general, I mean, from ex parte reexamination all the way to post-grant review and all the ones in between, haven't they introduced a sort of chaos into into preclusion? And I'm referring specifically to the case that I just recently read, which is Saris versus Knowles Engineering. And I can summarize if people don't know, because that involves the ITC, the PTAB, and the CAF, the Court of Appeals of the Federal Circuit. It was just recently decided.
So I haven't read that particular
Okay.
case, but so if you want to talk about
basically,
the facts, that would be helpful.
Knowles Engineering had some claims which were litigated at the ITC and found valid. It was appealed to the Court of Appeals of the Federal Circuit, which agreed the claims were valid. Then Saris challenged in inter partes reexamination, where the examiner canceled, was upheld by the PTAB. They also introduced new claims. This then was appealed. And Newman said that this, we've already held that this is litigated, and we are the court that we have the adjudicatory authority, and we don't go back on our decisions.
Well, certainly there were some early cases after the creation of the PTAB where the Federal Circuit sort of took a absolute finality position on these questions of preclusion. So the Versada case, and there were a few others where there was litigation in the courts,
Yes.
and the patent was determined to be not invalid, right? And then there was an infringement finding, and damages were awarded, and there was an appeal to the Federal Circuit, and then the accused infringer went to the PTAB, and the patent was invalidated, and then that decision was appealed to the Federal Circuit, and the Federal Circuit affirmed the invalidation and applied this sort of absolute finality rule because the earlier decision from the federal court was not absolutely final. Now, to be fair, looking at general preclusion doctrine, that is not how it generally works. Generally, a district court decision can be preclusive even if it's subject to appeal. But if that district court decision then is reversed on appeal, any decisions that sort of that relied on it from a preclusion perspective would also be reversed.
Yeah,
So the Federal Circuit did sort of take a different approach with this absolute finality rule, and I mean, there are different ways, I think, to address this, and Paul Guglielmo has written about this, and I think others, and stays is certainly one procedural device that can be used to try to avoid these situations, and I think that with time, some of these issues arose at the very beginning, and so with time, maybe courts are a little bit more willing to stay when there's parallel proceedings to try to avoid these sort of potential conflicts.
Yeah, in this case, the Court of Appeals of the Federal Circuit held that the patent was valid. The claims are valid. And this is what the inter partes reexamination overturned. Wallach and Chen actually introduced new grounds for invalidation so that they could agree with the PTAB.
Right. I understand you said the court held that the patent was not invalid, right? So the patent owner.
I read her decision. She said that it was valid. She didn't say that it was not invalid.
Well, yeah, I mean, Judge Newman has always been
Yes.
quite concerned about this sort of
Issue.
sense of the agency perhaps effectively, in her view, kind of overturning prior court judgments. And, as Megan has indicated, the regime we have is another area where the way the regime works is bulky, and there are timing issues where, again, it would be helpful to revisit this. I know in the pharmaceutical context, for somewhat different reasons, a lot of pharmaceutical companies think that the sort of AI proceedings are really messing up the timing that they've come to expect with regard to ANDA litigation, a particular type of litigation that was meant to help resolve issues with regard to the infringement of pharmaceutical patents, quickly and sort of separately from the normal processes we would have in the courts. And that's just another separate area where the sort of negotiation of the sort of proper relationship between the administrative review proceedings and the courts probably could use some working out more smoothly.
Professor Keith Hilton, Boston University.
Thanks, Eric, and thanks for going through the policy arguments, because I just wanted to talk briefly about those. You mentioned deference and issue preclusion, and so the first two you mentioned are issue preclusion were economy, error correction. I guess you could add to that the costs of errors. But also there's this issue of the potential for free riding and the deterrence implications of that in the case where you're looking at issue preclusion, because maybe there's the wait and see incentive on the part of a later litigant, let someone else go ahead, and to the extent that you have that kind of free riding, it affects deterrence, it affects social welfare. So there's a broader concern about the broader implications of issue preclusion, taking that into account. With deference, I agree with your list. You said expertise, political vulnerability, or the capture question, your public choice issues. Jonathan mentioned predictability and stability, which strikes me that ought to be on the list. And it would seem to be, so John, you said that it would be an argument for less deferential review, and it seems to be a pretty strong argument in most cases, because you take examples like the NLRB, where you have the well-known policy oscillation problem. A new administration comes in, completely different position on some question in labor law, and just these swings that happen every time the administration changes. So it strikes me that you want to avoid that in areas, and maybe the predictability and stability concern should start off, as the major concern, and then figure out from there, when you want to make that a less important concern.
Right. Yeah, I should note that I was cribbing there from, again, my administrative law professor's comments earlier, Todd Rakoff, who kind of raised that. I do think, and yeah, I agree. I think in the patent regime, in IP perhaps more generally, there is something of a check, you might think, on the tendency of the administrative agency to reverse itself in significant ways, partly because it seems like the Patent Office has a significant interest in kind of harmonizing its regime with that of other nations under our sort of international treaty regime, and so that they can pool their work efforts in patentability review to a certain degree. That certainly seems to, at least from my perception, has informed or seemed to align a fair amount with some of the PTO's stances with regard to sort of questions of, say, the breadth of the grace period provision we have remaining under the AIA. And that might mean that, at least from a practical standpoint, we might have less of a concern about the agency quite so freely oscillating back and forth. But I agree that, and it's the reason I raised it before, that it is something of a factor that probably should be in play from a policy standpoint.
Yeah, and I would just add, though, that I think the NLRB is like sort of a quintessential politically charged agency, and maybe the Patent and Trademark Office would move in that direction if they were getting Chevron, but I think there's aspects, that are less political that we would see those types of swings, and there's at least aspects within, because most of patent law is supposed to be across all technology, there are sort of built-in groups that diametrically oppose the two biggest lobbying groups of the ITC and pharma, right? So there's some aspects that we may think will cut against that. And then I just want to add in, which we haven't talked about yet, was that, so the Fed Circuit now gives the Patent and Trademark Office no deference for its legal interpretations, right? Which I think is not defensible under administrative law principles at all. So I even think moving towards Skidmore would be a good movement for the Federal Circuit, because they're just resisting it all on the legal determinations.
I will just add, at least as regards consistency, so while Chevron clearly contemplates giving agencies flexibility to change their minds, if Skidmore would end up being the standard, consistency is a factor for deference under Skidmore. But moreover, even under Chevron, if an agency changes its mind, if an agency reverses position, it's always susceptible to challenge under the arbitrary and capricious standard. Because inconsistency has to be explained in ways that pass muster with the court separately. So, on the one hand, yeah, there are instances, and the NLRB is a great example, where we have kind of a persistent problem of policy oscillation. Nevertheless, there are checks against that in general administrative law principles for precisely the normative reasons offered that inconsistency is just not optimal or even desirable.
Okay, our panel's now out of time, but John Duffy has a question. So why don't you ask it succinctly if the panelists have succinct answers too. So John Duffy, Virginia.
All right, I'll be very quick. I just wondered, given that the AIA grants the rulemaking power that it does have in it to the director, and the director has not delegated that rulemaking power to the agency, wouldn't the decision delegated to the PTAB, wouldn't that mean that that under the Martin versus Oshrock decision, that if there is any Chevron power in the agency over inside these proceedings or with respect to AIA proceedings, it would be held by the director and not by the PTAB panels, even assuming that we consider those like formal adjudications, doctrinally.
So, and I hate to respond with respect to patent, but if you've got something, then please.
No, I want to hear what you have to say.
Well,
I don't agree with that, but go on.
Well, what I was going to say was simply my understanding, and you can correct me if I'm wrong, is that the rulemaking power that the director has is somewhat limited as to subject matter. And so consequently, yes, if in a matter where the director has rulemaking power, the director and PTAB directly disagree, then the director's view, I think, would trump. But at the same time, that doesn't mean that PTAB is Chevron ineligible with respect to other aspects of its decision making.
That would be my point. So in part, I think it's sort of what Judge Moore was arguing in her aqua products, right, concurrence, right, that you could argue at least some of the specific aspects that have been enunciated in the Patent Act as the director shall prescribe regulations for these particular things, right, that maybe you need to do that through rulemaking, right? But it's also not clear to me how much of that you have to do. I mean, it seems almost impossible that you have to do everything through that rulemaking, because there are going to be aspects that come up in PTAB adjudication that they're going to have to decide. So I guess I would echo what Kristin said, and I could maybe envision some aspects where you could get play if it was the direct, explicitly enunciated in the Patent Act.
Okay, so we were a little over time, but we're still leaving 15 minutes for break, so I think panel 4 will start at 3:15. But before then, please join me in thanking our 4 panelists.